Honorable Chief Justice Hayut, His Excellency, the Swiss Ambassador, Mr. Rock and his deputy, Dr. Jaffe, member of the Committee on the Rights of the Child, Professor Cohen, Professor Blecher-Prigat, and Professor Shoz, my dear Charuv colleagues, fellow children lawyers, ladies and gentlemen, good morning. Let me start by saying what an honor it is to be able to listen to Justice Hayut and Dr. Jaffe's comments and insights on this topic. And I would like to take this opportunity to also thank Professor Blecher-Prigat and Professor Ona Shoz for facilitating this event, as well as our Charuv dear colleagues. This conference celebrates 30 years since the birth of the CRC, and while these 2 days are packed with fascinating topics relating to all aspects of children's lives and rights, I believe it's only fitting that the right of access to justice is given a special place on the agenda in our attention. Because as our two distinguished speakers indicated, access to justice can be either an entry point or an insurmountable barrier in realizing other basic human rights. This is always the case, but it's specifically the case with regard to children that are often completely dependent on others for realizing and promoting their basic rights. I would start by introducing who we are, our service, a lawyer of my own, and then briefly list some of the barriers that we encounter as children lawyers in Israel in promoting and protecting the rights of children we represent. And finally, I would like to briefly put a bit of the air of the optimistic balloon we have about the situation of access to justice for children in Israel and try to look where we can do better. Just shortly, we are 90 lawyers specializing in representing children in civil proceedings, mainly in child protection proceedings in youth court or in adoption proceedings in family court, also representing children in acute family law proceedings, as well as representing children victims of severe sexual offenses in criminal proceedings and related civil proceedings. Children get a special representative, can receive a special representative either through a court decision, by most often by youth court or family court, or they can also approach us independently. This is granted to children over 12 or 14 years old, and based on a single eligibility criteria, which is the possibility of a conflict of interest between the child and his or her legal guardians that prevent them from protecting or promoting their rights. Like I mentioned, we are 90 children lawyers, all spread all across the country, from all segments of the Israeli society. We try to match the child with the best possible lawyer he or she need. The lawyers are managed, recruited, supervised and guided by 6 district child representation team within the legal aid department at the Ministry of Justice. We all undergo an accreditation multidisciplinary training, 1-year training facilitated by Charuv Institute, which includes, among other things, a toolkit to speak with children, understand children, and establish a long-lasting trust relationship with them. Our agenda is very simple. We are here to make sure that the best interest of the child, and only the best interest of the child, and not the generic child, but the specific child, is at the center of the decision-making process, and that nobody replaces the child's direct participation in the process. So we are not talking, if I'm to refer to Dr. Jaffe's very important comment, we're not talking about placebo representation, something that is meant to come between the child and the decision-making body. On the contrary, and I think it's not a coincidence that since we started representing children in youth court, the percentage of children directly heard by youth court has grown exponentially from 7% in 2007 to, I think, almost 100% today. We represent more than 4,350 children each year. The majority of them are children at risk. And before coming to Sarah's story, that illustrates some of the barriers children children we represent encounter. I would like to say, to refer to what Chief Justice Hayud referred to as the children's version of access to justice, which is the right to participation. And indeed, traditionally, until recently, the right to access justice as we understand it as adults, which means due process, fair trial, the right to representation, the right to access courts, the right to effective remedy, was mostly not applicable to children. Children were granted by the Convention on the Right of the Child what I see as a diluted right, the right to participate, which means that they have the right to be heard by the decision-making body. But that is basically it. But as we heard from Dr. Jaffe, this is no longer the case, and access to justice is now emerging as a distinct subtopic under the larger umbrella of children's youth rights. And as children lawyers, we see on a daily basis that despite being told over and over again that the court is no place for a child, children have a very, very strong sense of what justice is. It is what most of them call fair, something we all recognize deep down if we're uneducated, misinformed, ill-informed, or do not understand the language of the legal proceedings, especially then. If I'm prevented from filing a petition to enforce my rights, prevented by law, geographical, financial barriers, it's not fair. If the other party is represented by a lawyer and I am not, it's not fair. If the judge makes a ruling based on written reports she has read about me, reports I have not read or have read and disagree with, it's not fair. If someone is allowed to represent me but I feel they are working against my interests, it's not fair. If I cannot appeal, present evidence on my behalf, question the other side's witnesses, if judgments are made before I'm given a chance to present my case or given ex parte or not transmitted to me or not explained to me, it's not fair. And unfortunately, this is still a given reality for many of the children we represent. And the right to participation does not answer, not always gives an answer to this feeling that children have that the decision-making process has been done in an unfair way that they cannot support. It is inspiring and moving to have heard the strong voice of Chief Justice Hayud speaking in Israel about a new social contract between the judiciary and children. And indeed, this is a voice we now hear more and more from the Supreme Court, not as often from lower instances. And we more and more see that decisions in the Supreme Court are not taken without listening directly to children, without giving due weight within the decisions to the child's voice. Even in the end, the decision that is taken is different, and the decision about the best interest of the child is different. More often than before, we find courts meeting with children, listening to them, and in some cases giving way to their will in the decision-making process. But participation, I feel, is not enough. It is, if you wish, a mini right, a diluted version of the right to access justice. And I would like to illustrate this by telling you Sarah's story. Sarah is 14 and a half years old. She comes from a religious family. Since the age of 11 and until recently, she has been the victim of sexual abuse by her brother, who is now 17 years old. The abuse came to light only when her brother assaulted her friend, because Sarah herself knew that if she was ever to disclose the events, catastrophic results will come upon her. Sarah's family does not explicitly side with her brother, but they are pressuring her to forgive him, put all this behind, recant the complaint, and ask for leniency for him. He is now in juvenile correction facility undergoing a rehabilitation process, and she as well is the subject of dependency proceedings in youth court and is placed in alternative care, a boarding school for religious girls. The dependency proceedings begin in a district where the family lives, and the youth court judge appoints a guardian ad litem, an independent representative for Sarah. But then the parents move to a different district to be closer to the facility where the brother is, and the case moves with them, although Sarah resides in a different district. And in the new district, the youth court believes that there is no need for separate representation anymore and dismisses the guardian ad litem. When Sarah's weekends or holidays from vacations from the boarding school coincide with her brother's, the family prefers to receive him at home and not her. And she remains in the boarding school when all her colleagues and friends go home. The criminal proceedings against Sarah's brother are in motion, and in light of his rehabilitation progress, the state attorney offers him and his family a plea bargain. Sarah's brother is accompanied to all hearings by his parents, while she is never informed of the hearings and does not attend them. Sarah's parents and brother agree to the plea bargain, and she is pressured to consent as well. She is unaware of her rights as a victim of a crime, including her rights to separate representation. One day, her parents come to visit her at the boarding school and take her out as a surprise for ice cream. During their outing, they have a conciliation phone conference call with the brother. Upon her return to the boarding school in tears, Sarah asked the staff not to allow surprise visits from her parents anymore, and she's replied that it's their inherent right to see her whenever they want. Sarah wishes to begin therapy to deal with her trauma. Her parents do not explicitly refuse to sign the consent, but drag on signing the forms, and she does not receive the therapy she most desperately needs. Her mental situation deteriorates. The boarding school has a hard time dealing with her behavior. They expel her. The family refuses to take her in. She arrives at a psychiatric emergency room after attempted suicide. In the absence of alternative placement, she remains in a closed psychiatric ward for 3 months. She is under the age of 15, therefore is not entitled to appeal the decision or to have a separate representative. Based on parents' consent and Sarah's hospitalization mental status, the court approves the plea bargain in her absence. While Sarah is in the hospital, her father dies, leaving a will explicitly excluding Sarah from the estate. Sarah, with the help of a devoted social worker, wants to challenge the will, but the fees that are required by court to instigate such a petition are extremely high, and she cannot bear them. Obviously, there is not one Sarah, thank God, but the story that I'm presenting is comprised of true life events of children we have represented only in the past year. So I think this incorporates all the barriers that prevent children from accessing justice that were mentioned by Chief Justice Hayut and Dr. Jaffe, and this is just to list a few of them. But coming to a close and looking forward, let's think about what is needed to enable children to have justice. Again, this is something that Dr. Jaffe referred to, and this to have, first of all, I think, a shift of consciousness, an understanding that children are entitled with the same rights and a due process as adults, only with added protection because of their special rights, special status as children. Training, specialized course system, child-friendly information, multidisciplinary teams, which is something we at Lawyer of Mine are trying to implement, interagency and cross-sectorial cooperation, and research into what are doing, to see if what they're doing is the right path and is compatible with what children needs. And 2 last minutes looking at the Israeli system. I'll start with the A's, where we fare well, and I think Israel prides itself with a robust and comprehensive normative child protection legal framework, and also mentioned at length by Chief Justice Hayut. We have child protection centers when this was only in diapers in other countries, in Western countries. We have a comprehensive evidence law that grants special protection to children that are witnesses or victims of the crime. We recently have a new foster care law that incorporates verbatim the Convention of the Rights of the Child with regard to children in alternative care, a new ombudsman for children in alternative care, an universal mandatory right to be heard in family law proceedings, which is something that my dear teacher, Dr. Tamar Morag, promoted, and again, a universal mandatory right to be heard in protection proceedings. So this is all really, really optimistic and good. So where do we fail? Where do we fall short? The B's and the C's. I think we as lawyers, seeing ourselves as advocates for children's rights, we have a dented perception. So what we mostly feel is missing is a gap between the law in books and law in action. A good example of this is, I think, a bad example, but a good remedy is the fact that, again, the mandatory right to be heard is not universally implemented in both in family law and child protection proceedings. And I was very excited and moved to hear about this initiative of the judiciary to have training for judges in order to be able to implement this and bridge this gap. We still have missing chapters in law books if we do not have the right to separate representation for children in all proceedings in which there is a conflict of interest between them and their legal guardian. If we do not have an universal mandatory representation, right to representation and due process for children that are placed in psychiatric forced hospitalization, which we can all agree is one of the most severe forms of rights violations possible, then I think we still need to fill in some chapters. Again, child-friendly information, this was very clear in the case of Sarah, that she was so close to having the tools and the means and the door open to her proceedings that are deciding their destiny, but in the lack of information she has and the professionals working with her have or give her, this is an insurmountable barrier. About complaint mechanism and what I mentioned, monitoring and accountability mechanism. I think this is one of the most important things. Again, because children cannot complain about the services they receive, then they do not have political power, they do not have market power, which is nowadays even more important than political power. We need to have in place strong, well-funded monitoring and accountability mechanism. And I would like to thank Chief Justice Hayut for her initiative, an excellent example of monitoring mechanism that helped bridge the gap between the rights on books and rights in action with regard to children victims of crime. And these are the guidelines of the Chief Justice with regard to children victims and witnesses. I hope will help prevent cases like Sarah's from repeating themselves. So again, let me conclude by calling for a consciousness shift, a deep understanding of anyone working with children, especially children at risk, that children deserve a fair decision-making process on the same footing as adults, that the decision made about the child behind closed doors can never be in the best interest of the child, and it can never be, or seem to be, fair or just. And to put it in child-friendly terms, I would like to be able to prove the next time that I represent a child to provide a clear reply without stammering or staggering the next time a child's client of mine asks, "Where do I sit?" Thank you very much.